Now, our next speaker spent 10 years practicing as a duty solicitor and really has become one of the world's leading experts on PACE. And he has recently turned his powerful intellect to the analysis of legal aid provision in general. So it's perfectly right, and I'm delighted that we have with us tonight Professor Ed Cake. And the significance of the Act when it was passed.
Well, I think what's often forgotten is that originally, when the police arrested a person, from a legal point of view, under the common law, the purpose of arresting a person was simply to take them before a court. But what happened during the first 3 quarters of the 20th century was that the police increasingly took on the role of investigation, and using that period where the person was detained pending their court appearance for the purpose of interrogation. But we had this common law myth that the purpose was simply to put them before a court. And the consequence of that was that that period when a person was detained at the police station was entirely unregulated by law, and certainly unregulated by statutory law. There did develop the judge's rules, which did set out rights like the right to legal advice, the obligation to have an independent adult, the obligation to conduct interviews at police stations. But basically, I think they were most noteworthy because they were ignored by just about everyone, and that included many defence lawyers at the time. And there's a very sad case, really, both from many people's points of view, which is a good illustration of the kinds of things that went wrong. The case of Paul Blackburn, who eventually was succeeded in his appeal on a reference back by the Criminal Cases Review Commission in 2005. And he spent 24 years in prison for attempted murder and attempted buggery. Now, he was arrested during the mid-1970s when he was 14. He was interviewed at his approved school, not at the police station, no appropriate adult, no legal advice. And after intimidating interviews by the police, he eventually said that he'd done it. And that resulted, as I say, in him being in prison for 24 years. And all of those things were contrary to the judge's rules, but basically no one took any notice of that. The Callaghan government in the late 1970s was prompted to establish the Royal Commission on Criminal Procedure, partly as a result of another miscarriage of justice known as the Confate case, where 3 young men, one of whom was described as educationally subnormal in the term used at the time. And it was in the wake of that scandal that the commission was set up. The commission, we mustn't forget, actually did recommend that police powers be increased, and they were increased, the powers of arrest, powers of stop and search. But as a sort of quid pro quo, they recognised that there should be a statutory right to legal advice for suspects arrested and detained by the police. And they also recognised the truth that there's no point giving someone a right if they can't exercise it. So they also recommended the creation of a non-means tested legal aid scheme and encouragement for the creation of duty solicitor schemes. And in retrospect, quite amazingly, given that it was a Margaret Thatcher government, those recommendations were accepted in the Police and Criminal Evidence Act of 1984. And so the significance of that was, for the first time, there was a clear statutory right to legal advice for suspects. And I think the clarity and the simplicity of that right was very important, because it said that anyone arrested and held in custody by the police had a right to consult a solicitor in private at any time. And I think that the sort of simplicity of the right and the clarity was absolutely important. And so that is the sort of greatest significance of that piece of legislation. It also established regulations by which the police should operate, and it also led to the creation of the role of the custody officer, the requirement for the custody record, and ultimately the tape recording of police interviews, which also I think has been an absolutely critical development as a result of the case. Well, on a personal level, I mean, I had just set up a welfare law practice in Bristol with a colleague, Roy Douglas. And on a personal level, what it meant was that we then took it in turns. We would each spend a week on duty for out-of-office hours. So we often had weeks where, I remember sort of being at the police station at some time between 1 o'clock and 5 o'clock in the morning, and then having to go to court to deal with cases on the same day. I mean, the police fought hard against, in particular, the right to legal advice, and one of their immediate responses was to ask the Thatcher government to do a U-turn. Of course, she's well known for saying that she didn't do U-turns. This lady's not for turning. In fact, what they did get is they didn't get abolition of the right to legal advice, but what they did get is abolition of the right to silence, which was really the payoff. They fought hard against it, and there was a sort of running battle between defence lawyers and the police in terms of the kinds of strategies that they would use. And one favourite was to try to force the solicitor to sit in the corner of the interview room. And in some police stations, and I kid you not, the chair was bolted to the floor, and in some police stations with the label solicitor on the back. And I began to do courses for police station lawyers in the late 80s, and have been doing them ever since. I can't believe it's such a long period of time. And so we were sort of saying that, what did you need in your kit as a defence lawyer? And one of the things you needed was a spanner, so that you could unbolt the chair from the floor, or if that didn't work or it wasn't actually bolted, that you buy a hard briefcase so that you can sit on your briefcase next to your client. And it's quite interesting that there are actually parallels to that happening right now in other parts of Europe. And because legal advice at police stations is fought against by the police and by prosecutors in nearly every jurisdiction that I've ever been involved in. And there's a pilot project in the Netherlands at the moment, which is running for 2 years to provide legal advice, or give the right to legal advice, only in murder and manslaughter cases, and only in 2 cities, Amsterdam and Rotterdam. And the police would only agree to do this, even though it was being passed by Parliament. The police are very powerful. They would only agree to do this, firstly on the basis that the solicitor would have no more than 30 minutes consultation in advance of the police interview. And remember, this is only murder and their equivalent of manslaughter. And the other condition is that there should be no eye contact between the client and the lawyer during the course of the police interview. And this is in a written agreement. I've seen it translated into English. It's not a figment of my imagination. So what we saw in terms of the response by the police at the time is something which is not peculiar to England and Wales, and actually I've seen the same kind of thing around the world. In terms of lawyers, I have to say that the legal profession did not cover itself in glory, or parts of it didn't at that time. And one of the problems was, of course, that lawyers had to gear up to be able to provide advice on a 24-hour, 7-day-a-week basis, and many of them were simply not in a position to do that using solicitor staff. And what many of them did is to employ completely unqualified people to provide legal advice. And that became particularly significant, especially once the right to silence was abolished, because no longer was it possible, as some solicitors tried to pretend, that all you need to do is go and advise a person not to answer questions.
And in your recent work, did PACE really have any wider impact on the legal aid system as a whole?
Well, I think that ironically in a way, I think it did lead to a certain degree of professionalisation by the police, because prior to PACE, police officers had little or no training at all in interview techniques. There was a degree of professionalisation by the police, and the police did institute national training schemes for police interrogation with varying degrees of success, as some of you might realise when you're sitting there in the interview room. As far as the legal profession is concerned, I think it also did lead to greater professionalisation. Also, we saw the introduction of the accreditation scheme, initially for representatives and then subsequently extended to all lawyers. And I think the other consequence was specialisation. That at the time, and this is still true in most of the countries that I'm aware of around the world, there was very little specialisation, and many high street practices were completely generalist. And it became apparent that it wasn't possible to operate on that basis any longer. So I think it did have that effect as well.
Thank you very much, Ed.